Hi everyone, I'm Hayden. I'm today's moderator, co-speaker. Welcome to RDS Continuous Legal Education Series, organized under the name of RDS Academy. This series is part of our social responsibility, where our lawyers will be discussing the various areas of law which they practice and what they do every day. Prior to this, we've already had two sessions, one in July, conducted by our senior associate Sean, who specializes in arbitration and construction dispute. Another one in early August, conducted also by our senior associate Annabelle and Diane, where they have discussed about the intricacies of mergers and acquisitions, as well as due diligence. Today is the third of the series, where we will discuss about what is injunction and the applicable legal principles. I have here with me my colleague Clarence, who has been doing law for almost 3 years, and she specializes in commercial dispute and corporate fraud. I'm Hayden. I will also be today's speaker. I mainly do disputes regarding commercial contracts. I will now pass the floor to Clarence.
Thank you, Hayden. Good afternoon and hello, everyone. I hope that all of you are keeping well and safe. It's my pleasure to meet all of you and welcome you to our webinar on injunctions. So injunctions are described mainly as an order to restrain a party from performing an act. As you can see from the slides, there are various types of injunctions in law. First, we can see that there's interim or interlocutory injunction, which is temporary in nature. And it lasts for a period of time, either until further order or final hearing of the case. Perpetual injunction is a final injunction where the order is made at the end of the hearing. Prohibitory injunction is an injunction which restrains a party from doing a positive act. Mandatory injunctions is an injunction which compels a party to do a positive act. We have also quasi-timid injunction, which is granted against a threatened or apprehended wrong. So to obtain a quasi-timid injunction, the applicant must show the fear of an imminent grave danger. And we have also Mariva injunction, which is known as freezing order, where it is desired to restrain any dissipation of assets. And then pillar order, which is known as a search order, that is an order to enter premises and seize documents where it is desired to restrain party from destroying the documents. We have arraignment injunctions also granted to an applicant to preserve the status quo pending the conclusion of the appeal. So generally, the interim or interlocutory injunction is the most common injunction sought in court. So what are the sources of legislations in making injunction application? We can rely on few sources, as you can see from the slides. We can rely on Section 65, subsection 5 of the Subordinate Courts Act, 1948. Section 25, subsection 2, Courts of Judicature Act, 1964, and the paragraph 6 of the Schedule to Court of Judicatures Act. Section 50 to 54 of Specific Relief Act, 1950. Section 50 is about preventive relief, how granted. Section 51 talks about temporary and perpetual injunctions. Section 53 talks about mandatory injunction. And Section 54 is about when the injunction will be refused if you applied. And also last but not least, Order 29 of the Rules of Court 2012. So now, how do we apply an injunction in the court? So to apply an injunction in court, it has to be made by way of notice of application supported with an affidavit. In the event that your application is of urgency, you may file also a certificate of urgency together with your application. This is pursuant to Order 29, Rule 1, Sub-Rule 2 of the Rules of Court 2012. Where the case is of urgency and secrecy, you may make an ex parte application. However, bear in mind, in an ex parte application, there must be full and frank disclosure of material facts in your case. If you fail to disclose fully and frankly the material facts, your ex parte order will be set aside by the other party. As established in the case of Lim Song Hua and Syarikat Pemaju Tanah Tikam Batu Sdn Bhd. So, don't lie. The right to set aside by the other party is provided under Order 32, Rule 6 of Rules of Court. So now, one must be wondered, who can make the application? Is it solely limited to plaintiff? Or defendant can apply an injunction as well? The answer to this is it is not limited solely to plaintiff. If you refer to Order 29, Rule 1 of Rules of Court, it stipulates that an application for grant of an injunction may be made by any party. So any party here means that whoever can apply, and this includes plaintiff and defendant. In making an injunction application, another key provision is Order 29, Rule 1, Sub Rule 2A of Rules of Court, which sets out a list of information to be included in your affidavit to support your application. For example, facts giving rise to the claim, facts giving rise to the application for interim injunction, facts justifying the application, any answer which the other party is likely to insert to the application, facts which may lead to the court not to grant in the application, and a similar application made to another judge and the order made on that application. And lastly, precise relief sought. This information is mandatory to support your application. If any of the above is incomplete or missing, it will cause your application to be dismissed. And this principle is established in a landmark case of Motorsports International Limited and others, and Dalcon, Malaysia Sdn Bhd, which held that Order 29, Rule 1, Sub Rule 2A of Rules of Court 2012 must be strictly complied. The policy behind the Order 29, Rule 1, Sub Rule 2A of Rules of Court 2012 is to ensure that the ex parte injunction are only granted where they are truly necessary. However, there are circumstances where the court may still grant the injunction despite failure to make full and frank disclosure. That is, where the fact was not known or its relevance was not perceived by the plaintiff. Second, the defendant is not prejudiced. Right, at this juncture, I hope that I've not overloaded everyone with too much information and I've been easy to follow so far. All right, do submit any questions if anything is unclear. All right, so regarding the validity of the ex parte order, under Order 29, Rule 1, Sub Rule 1, 2B of Rules of Court, ex parte's orders are only valid for 21 days. 21 days, all right, bear in mind, it's 21 days. And after getting an ex parte order, such order must be served within 7 days of the date of the order, and the court must fix a date to have an inter partes hearing within 14 days from the date of order as required under Order 29, Rule 1, Sub Rule 2BA. The court cannot extend the period of the order. So to avoid having to make a fresh application upon the lapse of the 21-day period, a party can apply for an ad interim injunction pending the inter partes hearing. And this is well explained in the case of RIH Services Malaysian Sdn Bhd and Tanjung Tuan Hotel Sdn Bhd. In the case of Jack's Island Circle Sdn Bhd and Star Media Group Bhd and another appeal, it's a case which discusses about the need of an ad interim injunction. The reasoning of the court in granting the ad interim injunction was precisely because the application could not be heard immediately as both parties had not yet exhausted their affidavits. Because as lawyers, we all know that we have to file affidavits of support and then give chance to the other party to file the affidavit in reply. And thereafter, as a plaintiff, we have to final reply to their affidavits. So it takes time, 2 weeks, 2 weeks, 2 weeks. So yeah, in this period, you may apply for an ad interim injunction to preserve your status quo of the matter. So in determining whether to grant an ad interim injunctions, merits of the application will not be doubted because the whole intention, as I said, is to maintain the status quo pending the hearing proper of the inter partes injunction application. So we have been using the phrase status quo for a bit, but what does that actually mean in the context of granting an interlocutory injunction? Status quo here refers to the relevant period immediately before the plaintiff filed his writ of summons and his ex parte application for injunction against the defendant. However, there are instances in which an ad interim injunctions may not be granted. So take note. This includes the status quo need not to be preserved by an ad interim injunction, or where irreparable damage may be caused to the defendant by the grant of an ad interim injunction. So in considering of whether the status quo between parties shall be preserved, the court will actually look at whether damages would be an adequate remedy. So as many of the students and practitioners here are aware and probably sick of hearing, so the test for interim injunctions is set out in the case of American Dynamite and Ethicon, where the English court set out a 3-point test on when to grant an injunction. So in Malaysia, we have the Court of Appeal case of Jared Francis Noor John and Muhammad Noor bin Abdullah and others, which adopted the principles set out in American Dynamite. So first, there must be a serious questions to be tried. So how do we determine the serious question to be tried? The plaintiff need not show that he will succeed at the end of trial, but he must at least convince the court that there is a serious question to be tried. For example, if your case is regarding breach of contract, so whether there's a breach of contract, whether there's a wrongful termination of the contract, it might constitute to a serious question to be tried. And in determining whether there's a serious question to be tried, the court cannot go into the merits of the case because the merit should be dealt in trial. And second requirement is the applicant must show damages would not be an adequate remedy. So this means that if the plaintiff succeeds in trial afterwards, an award of damages would be sufficient or adequate compensation, then the interlocutory injunction will be refused. And damages will not be adequate if the plaintiff's loss is not monetary in nature. And if the plaintiff's loss cannot be quantified with precision, this means that damages will not be adequate. And defendants has no assets to pay damages. So the last one would be balance of convenience between parties. So when considering balance of convenience between the parties, court is required to consider the essential justice of the case. For example, as I cited in my slides, Syarikat Jeleta Bumi Sendirian Berhad and Nadaraja Laki Ramasamy. So in this case, defendants occupied the premises for several generations. It would cause greater hardship if the defendant were asked to vacate and demolish the premises because they are poor and they did not have an alternative place to stay. So in this case, the court take into consideration that the balance of convenience is favored to the defendant in this scenario. So in making an application as an ex parte, undertaking as to damages is important and is required before the courts actually grant you an interlocutory injunction. So why do we need this undertaking as to damages? Because the purpose is actually just to ensure that the other party is sufficiently compensated when the applicant is not entitled to the injunction in the first place. So court may not grant an injunction if the undertaking as to the damages is a bad undertaking. We can see in Net 7, TV Sdn Bhd. In that case, the judge hearing an application, it actually set out that the judge hearing an application, right, for the injunction is entitled to take into account the plaintiff's ability to meet his undertaking in damages should the suit fail. In appropriate cases, the judge may require the plaintiff to secure his undertaking, for example, by providing bank guarantee in the case where it seems that the plaintiff's undertaking is doubtful due to his financial ability. So for a company, how can they prove that their undertaking is not a bad undertaking, it's a genuine undertaking? They can actually rely on their financial statements or annual financial report, the latest one, to prove that they are financially sound. So after speaking of the interlocutory, the common interlocutory injunction, here comes the interlocutory mandatory injunction, which I would like to share. So what does it mean by mandatory injunction? As I explained in my previous slides, is to compel a party to perform a positive act. So when you apply for an interlocutory mandatory injunction and you got the order must state the time limit for performing such act. In other words, you have to state that what is the time limit or time period for the party to perform the act. It must be precise in that sense. But prior to the trial, if you are seeking interlocutory mandatory injunction, there might be a difficulty for you because as established in Tinta Press Sdn Bhd and Bank Islam Malaysia Berhad, the court has a discretion to grant an interlocutory mandatory injunction before trial in an urgent case. But they don't normally grant it easily because the discretion has to be exercised sparingly. And an interlocutory mandatory injunction can only be granted in exceptional and extremely rare cases. So how do we define exceptional and extremely rare cases? That is really from case to case basis. So Arifert injunction has tend to be confused by the parties or by us that because Arifert injunction and stay of execution of an order both have an intention to maintain status quo of the matter. So we will now look into Arifert injunction. So what Arifert injunction actually meant. Arifert injunction, the concept is actually arise from the case of in Arifert Properties Limited and Cheshire Country Council. So it says that a party can apply for an injunction pending appeal to preserve the status quo against the dismissal of the initial injunction application. So we can see that a party can apply for an Arifert injunction if your previous injunction application was dismissed by the court. And if you appeal against the decision by the lower court, you can now apply for an Arifert injunction. So to apply Arifert injunction, what are the tests that the court actually take into account when granting an Arifert injunction? So in the recent case of Welty, Grove, Sembian Berhad, Lee Swee-Ching, and others, it's established that the test would be likelihood of a successful appeal, branded nugatory, and also balance of convenience. However, bear in mind, this is an injunction. So other than to prove that your appeal would be succeeded at the end of the day, you do have to consider that to prove, besides balance of convenience, you have to prove that damages would not be an adequate remedy, which means that the court ultimately will still take into the consideration of the initial test, which I set out earlier, whether the damages would be an adequate remedy and also the balance of convenience. And they will take into consideration to your likelihood of the appeal, whether succeed or render nugatory. So we tend to confuse, like what I said, state of execution and Arifert injunction. Arifert injunction is actually not really same as the state of execution of an order. Both are actually different, I would say. Because in an application for state of execution, there is an earlier order. The court had actually made an earlier order granting a certain application, which can be executed by the successful party at the end of the day. So the unsuccessful party having power and appeal against the order, they will tend to apply for stay of execution. However, in the context of Arifert injunction application, the court had dismissed an earlier injunction application, and pending appeal of the said dismissal, the unsuccessful party that applied for a limited injunction pending the appeal. There's no order to be executed by the successful party in this case. Arifert injunction application itself is actually an original application, an application started by itself. Ladies and gentlemen, I guess that's all from me, and I shall now pass it over to Hayden to touch on fortuna injunctions and injunction against the government. Hayden.
Thank you, Clarence. That's a very comprehensive overview of what injunction is. Just to recap a bit of what Clarence has just said, a few things may be of interest. She's spoken about ex-parte injunction. That basically means an injunction that is granted when the court has only heard one party. Normally, the court will have to listen to both parties before giving an injunction. But because of the urgency of the matter, the court granted the injunction after hearing only one party. And that is also the reason why the ex-parte injunction can only last for 21 days, so that the person to whom the injunction is granted will not be prejudiced for too long. The second main point that Clarence had made, which I appreciate very much as well, is the test for interim injunction. The test is basically threefold, very simple. The first one is there must be serious issues to be tried. What this means is that both parties must have a real dispute, must have a real grievance to be addressed by the court at the end of the day. I can't just get an injunction for something trivial or something that has no legal consequences. That's the first one, serious issues to be tried. The second part is balance of convenience, which Clarence had also explained, is where the judges will exercise a balancing act. The judge will balance between the prejudice of not granting the injunction and balance it with the prejudice that will arise by the grant of the injunction. After balancing, then the court will decide whether to grant the injunction or not. In the event that it is evenly balanced, then the principle is to grant the injunction so that the status quo can be preserved. Injunction is all about preserving the status quo so that no parties can suffer prejudice from a change of circumstances. So those are the main point that my colleague has covered. I will now move on to fortuna injunction. And after that, I will address on the relationship between injunction and government. Fortuna injunction is the name may sound fancy. It comes from an Australian case. It's called Fortuna Holdings against Deputy Commissioner of Taxation. What this injunction does is to stop people from issuing a winding up petition against a company. The reason is, as the court in Fortuna says, is because the mere filing of winding up petition will cause damage to the reputation of a company. So this is mainly to prevent people from filing a petition, just to pressure a company to pay. So that is the rationale that underlies the Fortuna injunction case. In fact, in Malaysia, the court also recognized that the case about the reporting or publication or filing of a bankruptcy proceedings can have serious damage against the reputation. That's why in the Tan Ah Hong case, the Court of Appeal held that CTOS, in failing to take down a bankruptcy case from their database when it's already outdated, is a form of defamation. And the court has granted a nominal damage to this Tan Ah Hong. I will now move on to my next slide, which will address, the next slides will be about Companies Act. Why Fortuna injunction is commonly applied for only in one circumstance, usually. That is when a person, let's say I'm a company, I deal with another company, and the other company say that I owe him money, but instead of suing me and proving his claim, he sent me what we call a statutory notice of demand. Under section 466 of the Companies Act, if I do not pay back to him what was demanded in the statutory notice of demand within 21 days, then I am deemed to be unable to pay my debts. In that case, prima facie, the other company will be entitled to go to court and tell the court, hey, section 465 and section 466 applies together, and it shows that this company fails to settle a payment within 21 days. So I can wind it up. It is when, in practice, when companies receive such a notice of demand, that's when the company will engage lawyers and apply for fortuna injunction. Our next slide, because if this, look at going back. Going back up again. Yeah. Okay. How much must a company owe to be deemed unable to settle its debts? Prior to this year, it's 10,000, but this year, because of COVID, it has now been removed. Meaning that this period of time when COVID is the parties or litigants will not be allowed to send a notice, simple statutory notice of demand and use that as a basis to wind up somebody. The next slides will be on the test to obtain a fortuna injunction. The test to obtain fortuna injunction is basically twofold. One is that there is a bona fide dispute of the debt, meaning to say the debt is not established, it's disputed. And the second one is no chance of success. No chance of success is a rarer case. We will mainly focus on the second branch that the court in fortuna says, that is a disputed claim. The next slide is what the court sees as a disputed claim. It is not sufficient for a person to say that I have a good arguable case to say that he owes me money. That is not sufficient. Because if you have a good arguable case, what the court expects you to do is for you to go to the court and establish your claim first. And once the court decides that yes, you do have a claim, then you will get your judgment. And based on that judgment, you can issue a statutory notice of demand to demand payment. So the court do not expect you to skip that stage and straight away attempt to wind up someone. So that is why the court in SSAB tell that you have to prove your case first. A good arguable case is not sufficient to justify a wind up action. In the next slide, the court in Malaysia by Justice Darrell Goon, now Court of Appeal judge. In that case, it involves a retail mall, a retailer, a wholesale retailer, not to say wholesale, a retailer, as well as a landlord. So Parkson is an anchor tenant in many of the malls before this. So what happened was there was a dispute between Parkson and Millennium, the landlord, and Millennium straight away issue a statutory notice of demand against Parkson without going to the court and argue the case out. In this case, Parkson has go to the court and apply for a fortuna injunction. Justice Darrell Goon granted the fortuna injunction. In his judgment, he was critical. He said that Millennium Mall is issuing the statutory demand in terrorem. That is to say, to pressure someone into making payment, rather than using it to support a genuine claim, support a genuine demand. The underlying motive is to pressure and oppress the other side into making payment. So that is a very short summary of what an fortuna injunction is. To recap, what the fortuna injunction is to stop someone from presenting a winding up petition unless they have a very strong claim. For example, they have a judgment against you. Otherwise, the court expects a very high test that even a good arguable case is not sufficient. I will now move on to the injunction and the state. I think one saying is quite famous: no one is above the law, but we shall see whether that is true. Injunction, the court's power to grant injunction, the precise origin of it, there was some confusion. In the Court of Appeal, in the case of Kekatong against Dana Harta, seems to suggest that court's power to grant injunction comes inherently with the court itself. The court, by reason of being a court, can have the power to grant injunction. That's the basic suggestion by the court. But the case was, there was an appeal to the federal court, and that decision was ultimately reversed. Nowadays, I think it should be quite clear. It should be quite clear that the court's power to grant injunction is based on the Specific Reliefs Act, 1950. It is set out in Section 50. Section 50 is a general provision which is enabling provision to where the court derive their jurisdiction to grant an injunction, whether it's temporary or perpetual. Temporary injunction is usually granted when the case, there is a pending case in the court, then a temporary injunction is granted to preserve the status quo until a final decision is reached in the court case. All right, so here is the catch. Section 54 sub D says that no injunction can be granted against any department of the government. So that may appear to challenge our understanding that no one is above the law. In fact, if we move on to the next slide, the Government Proceedings Act, Section 29, says the same thing. It says that the court shall not, in any civil proceedings, grant any injunction to make any order against an officer of the government. So from the face of the word itself, it is very comprehensive. It means that it almost suggests that the government has absolute immunity against any form of injunction. But there is a disagreement between amongst the law lords as to whether that is true, because it does challenge the notion that no one is above the law. In the next slide, you will see that the court, in different occasions, taking a very different stance. In Sub Il Mulia, Justice Gopal Sriram said that it is a well-settled position that Section 29 does not prohibit the court from granting temporary injunction. So what the court is proposing is that Section 29 only stops the court from granting perpetual injunction. It does not stop the court from giving a temporary one just to preserve the subject matter of a dispute or preserve the subject matter of a court proceeding so that it's not destroyed before the court has the chance to hear the dispute. It's to preserve the subject matter. That's why a temporary injunction is needed. But fast forward 8 years later in 2013, also the Court of Appeal, it says that an injunction, interim or interlocutory or permanent, cannot be granted against the government. This is the age-old notion that the state shall have absolute immunity against the law. Hence, in the following slide, you will see where the dilemma lies. What will happen when the court is deprived of the power to grant injunction against government? The facts of this case will show that. In this case, the plaintiff was employed by the government to carry out a project. As a term, the plaintiff is required to provide the government a bank guarantee of tens of millions. But the government subsequently unilaterally terminated the project and attempted to call the bank guarantee. So what the plaintiff does, the plaintiff rushed to the court and get an interim injunction. Ultimately, the court says that, the court declared that government's calling of the bank guarantee is unconscionable. It shouldn't be done. It shouldn't be done. So the government was not happy. The government filed an appeal to the Court of Appeal. but it is not heard yet. No cases are heard right away. The court takes some time. So the appeal is not yet heard. But the government has quite quickly made a second attempt to call the same bank guarantee. The second call. That forced the plaintiff to rush to the court again with a new suit asking for an interim injunction to stop the government from doing that. Before the court, the senior federal counsel for the government basically tell the judge that, Judge, Section 29 says that you are not to grant an injunction against me because I'm government. So I can call, you cannot grant an injunction to stop me from making the second call. That is what they are trying to suggest. That's what the stance of the government. Justice Lee Swee Seng, now Court of Appeal judge, was very critical of the senior federal counsel's argument. It is quite obvious from his judgment. He said, I must be pardoned for not being able to follow the logic of that line of argument. Surely the learned SFC is not suggesting that the declaration granted by the first court has no effect whatsoever. In the next line, he's saying that surely the SFC is in effect saying that whenever the government is unhappy with the declaratory order, they will just have to do the very same act again in defiance of an earlier court order. This is the implication of the court being deprived of the power to stop the government. That's why in this case, Justice Lee Swee Seng had no hesitation in granting the interim injunction to stop the government from making the second call. So to the basis of the suggestion that the court cannot grant injunction against the government is not without merits, because ultimately government carries a lot of function. It is a public, it carries a lot of public services. It provides public health care, taxation on a national scale. So an injunction that constrains their action may have effect on the functioning of a state mechanism. But as PwC Bina case has shown, it is still necessary for the court to have the power to grant an interim injunction. After all, if any disruption is caused to the government's function, it is only temporary. It is not perpetual. And with nowadays, the court are very efficient. Cases are usually resolved within a year, sometimes shorter. There is really no excuse to say that the court should not, that the government cannot be injuncted. But because, to conclude the present state of the law, there are different courts taking different stance at this point. So the ideal situation is for the Court of Appeal or the Federal Court to have another chance to listen to these kind of cases and to clarify whether the court still has the jurisdiction to grant temporary injunction. One final point I would like to make is that what is government? It surely covers, for example, the Inland Revenue Board, but government is the definition of government do not cover local government. For example, Majlis Bandaraya, Majlis, all these Majlis, they are not seen as a government. They are not seen as a department of the government. In fact, our firm has carried out a few cases where there were contract between our client with Majlis, but Majlis had wanted to terminate it, we say wrongfully, and we managed to obtain a temporary injunction against the Majlis so that the Majlis cannot enforce that termination. So that ends my note. I see that there is a couple of question and answer. Clarence, the first one is addressed to you specifically. The question is, hi Clarence, is injunction and the writ the same thing? Perhaps you can try to give a bit of an explanation on that.
All right, thanks, Hayden. Is injunction and the writ the same thing? Okay, well, the answer is injunction and writ are two different things. Writ is a procedure and an originating process to your claim or to your suit. So you have to file your writ supported with your statement of claim. Injunction is a separate application for you. It's either to restrain someone to perform an act or to compel someone to perform an act. So there are two different things. All right, Hayden, I think this is to you about injunction against government. So can we apply for an injunction against the government to prevent an execution of proceeding when we have a court judgment, or do we file for contempt?
This is a very similar situation with the PwC case. PwC is exactly a situation where the litigant had obtained a court order beforehand, asking the government to not do the thing, but precisely the thing the government did again. So the litigant has no choice but to rush to the court. From the case of PwC, it appears that given the circumstances of the case, the court may grant an interim injunction to stop the government from ignoring or disregarding altogether the earlier judgment. Okay, I think this is about, I saw a question about full and frank disclosure that you mentioned just now. So Clarence, there is one person who asked, to what extent the disclosure of material facts should be made?
All right, to what extent, I should put it this way, there's no limit for you to put in material facts. But based on my past experience, the best thing when you apply that injunction is that you put in whatever material facts, whatever facts leading to the events and leading to your application for an injunction, which means that don't be afraid that if the facts is not in your favor, because under Order 29, Rule 1 to Sub-Rule 2A, it requires you to put in the possible answer from the other side, which would oppose to your injunction application. Yeah, so there's no limit for it, but it's better for you to disclose whichever material facts is in your possession and within your knowledge.
If I may just add on to that, because full and frank disclosure is a requirement in all ex parte applications. As I've said, ex parte is where the court make a decision after hearing only one party. So the court expects you to disclose everything before him so that he can make a fair decision. Otherwise, when the other party come to the court after 21 days, the court will feel that you haven't been upfront, and that's quite a big taboo in the court. As we lawyers always say, you must come to the court with clean hands. Otherwise, it's like telling your girlfriend that she's your first love, only to realize that she's not. after a marriage. All right.
Yeah, to add on to Hayden's answer just now. So yeah, full and frank disclosure. So because injunction is a discretionary and equitable remedy. So yeah, please come with clean hands.
I'm seeing another question to say that what is the difference between a stay and an injunction? If you don't mind, I take that on, Clarence.
All right, sure, please, Hayden.
Okay. A stay and the injunction, the difference is basically one thing. Stay applies when there is an existing decision of the court or existing decision of the government. Then you apply for stay to stop either of them from taking force. That's a stay. An injunction, on the other hand, there is no such decision, not by the court, nor by the government, but it's just to stop a private action of the litigator, of a private party, or in some time, the government. Should I pick one for you, Clarence?
Yeah, I see that there's a questions regarding.
I'll leave it to you. Yeah.
Yeah, can we file notice of application for an injunction without filing a writ or SOC? Oh, that is interesting. All right. Okay, the answer to this is yes, we can do so. We can file notice of application for injunction without filing a writ or SOC. However, do bear in mind, there is actually a time limit for you to file your writ or statement of claim after getting the ex parte order for your injunction. This is provided under Order 29, Rule 3 of the Rules of Court, where it says that your writ has to be issued within 2 days after granting of the injunction or any other period which allowed by the court. Otherwise, your injunction will be discharged. So please bear in mind, don't miss the time limit if you file the notice of application without filing your writ first. Hope that clarifies.
There's one question. It says, what are some of the extenuating circumstances that the court take into account when deciding balance of convenience?
All right. If you don't mind, Hayden, I take that.
Yeah.
All right. What is the difference? Okay. What is the extenuating circumstances? All right. When the court is taking into consideration about the balance of convenience, they would think about the balance of the risks of doing injustice. So basically, the court will actually look at the position of each party and to balance who will suffer greater if the injunction is granted. So if the balance of convenience is not clearly favored either party, there is a need to consider the importance to preserve status quo. Also, the court will take into account about public interest and also relative strength of the party's respective case. So it is actually very fact dependent. It's fact to fact, case to case basis. Yeah.
If I may add on to that, we have handled a few cases as well. Normally, the court will pay a greater weight if third parties are affected by the grant or the refusal of the injunction. For example, I've raised an example where we have helped our client to obtain an injunction against Majlis for what we say a wrongful termination of contract. In that case, we informed the court that if Majlis is not stopped from terminating the contract, if it's not stopped, our client will have to remove all his staffs and employees that has been performing the contract. During this pandemic season, most of them will be affected. They may lose their job. They may suffer a pay cut. So the court listen to our argument and agree with us that the balance of convenience tilts in our favor to grant the injunction. So those are the few, it's not exhaustive, it's definitely by no means exhaustive, but those are a few factors that the court will take into consideration when we talk about balance of convenience. Clarence, do you want to pick one?
All right. Let me see what else. Right.
Stall for choice.
Too many to answer. All right. 21 days, there's a question. 21 days means upon getting ex parte injunction, the contractor must enforce it. Mind to clarify. All right. 21 days is the validity and is the time period for your ex parte order. So it does not mean that you have to enforce it. Between these 21 days, which means that if for a contractor, for example, if you are the contractor, you apply an injunction to prevent a party from entering to your site to carry out works. So if the court grants you that injunction to do so, so within that 21 periods of time, the other party cannot enter to your site to carry out whatever activities that's required. So after that, but upon that 21 days, if it's lapsed, then it's time for you to apply for an interim injunction, like what I have mentioned just now, because there's still an inter partes hearing going on. This is just to preserve your status quo. Yeah, Hayden.
If I may add on to that as well, under the rules, the court requires whoever who has gotten the ex parte order to serve the order within 7 days. The purpose is to make sure that the other side gets notice of the injunction so that he's not kept in the dark. As I've said, ex parte injunction is a situation where the court gives a decision without hearing the other party. So there is a lot of safeguard in place to ensure that there is no significant prejudice that can be suffered by the person against whom the injunction is granted. So there is a 21 days limit. There is a requirement to serve the ex parte order within 7 days. As to whether you enforce the ex parte order, in practice, what will happen after you've gotten the ex parte order is you will write to the person telling him that you have gotten the ex parte injunction. The injunction stops you from doing this, this, and this. And in the event that you disregard, disobey the order, you may be in contempt of court. That's in practice what will happen. So we will tell the other side that all this that has happened and when party should return to the court to see whether the ex parte injunction should go on or not. That's the practice side of it. I'm looking at another question which says that can a party apply for an interim injunction to preserve a right that would expire at the time the application is being heard? Clarence, do you want it? The question is, can a party apply for an interim injunction to preserve a right that would expire when the application is heard?
All right, got it, Hayden.
Yeah.
That would expire at the time the application is being heard. What is the application means? Is it injunction application? Then it would be related to interim injunction and it's not interim injunction itself.
Yeah, I think what will happen in this kind of situation where your right would expire when the application is being heard. If you all follow a bit of the federal court case, you will notice that what the court always say is this: the court will not entertain an academic application. Academic application means a redundant application. So in your situation, by the time the application is heard, your right would expire anyway. So it is very likely that the court will not entertain the application. Especially, the court views injunction as a very intrusive nature of remedy. The court always try not to grant it unless you can show that the balance of convenience really requires the grant of the injunction. Clarence, do you want to pick a question?
All right, I'll go for what is the requirement for getting an ad interim order? Is there anything that we should be aware or careful of before getting such order? All right, ad interim order is actually just to preserve the status quo of matter, to prevent anyone from intrudes to each other's rights. So there is actually the only concern that the court will take into the court will take into consideration is whether ad interim order, ad interim injunction is necessary for you or for a party to preserve the status quo. This is the only concern that the court will take into consideration. If there's no need to maintain the status quo, as I have explained earlier during my presentation earlier, the court will not grant you an ad interim injunction.
If I can just add to that, ad interim injunction. Okay, let me begin with ex parte. What usually happens is injunction is usually sought for urgently. So normally it's made by way of ex parte. So we'll have an ex parte injunction for 21 days. But after 21 days expire, the injunction automatically ends. Automatically. So the party injuncted will be free to do what he was restrained to do last time. So the court usually in these circumstances will say, all right, I cannot give you more than 21 days for ex parte, but I can give you what is called an interim injunction, so that the injunction would remain in place until both parties can finally formulate their argument and fight out whether the injunction should continue or should cease. So ad interim is more like another very temporary measure to bridge the gap between the expiry of 21 days and the hearing of the parties. So that's what ad interim injunction usually is.
Hayden, there's a question. Would you recommend setting aside an ex parte injunction on discovered grounds of lacking full and frank disclosure, or to raise or oppose the same later in the inter parte hearing? Would you like to answer this?
Come again?
Would you recommend setting aside an ex parte injunction after discovery grounds of lacking full and frank disclosure, or to raise or oppose the same later in the inter parte hearing?
It's not setting aside, application to set aside the ex parte injunction and the hearing for inter partes injunction are not mutually exclusive. Most of the parties will file the setting aside of the ex parte injunction, even though it would have been expired. The reason is to show that the applicant was wrong to have asked for the ex-parte injunction. To show that it is so wrong, it has to be set aside. The practical effect is that if the court agreed that the ex-parte injunction should be set aside, then the person who is challenging the injunction will be entitled to damages that he suffered because of the ex-parte injunction. So in practice, it is advisable that if you are resisting an injunction, you should not only wait for the inter partes hearing, you should also file a setting aside of the ex-parte injunction.
Yes, to add on to what Hayden has answered in relation to these questions, I have handled one case previously where we applied to set aside the injunction based on the grounds of lacking full and frank disclosure, and it was succeeded. So like what Hayden has said, don't sit on your rights and wait until inter partes hearings. Do it when you have the first opportunity.
Clarence, do you want to do the honor of finding the next one?
I see there's one question. Would you like to answer that as well? Can I apply for injunction using an OS instead of writ?
Okay. There is no, the choice of OS and writ depends on the complexity of your underlying dispute. If, for example, the dispute is about harassment, it's very fact heavy. So it will usually be begun by writ. And you would also ask for interim injunction to stop him from harassing you meanwhile. That's a that's a situation where you file a writ and then you get an interim injunction. But there is also a situation where you file an originating summons, or what we call OS, instead of writ, and also asking for interim injunction. A very good example is how we apply for fortuna injunction. Fortuna injunction, the facts are usually very clear-cut. That is, you send me the statutory notice of demand, you threaten to wind me up, so I am suing you by OS to stop you from doing that. Very simple fact. So that's a situation where you start a suit by OS and you got the interim injunction. So you can get interim injunction, you can apply for interim injunction in both situations. There is no impediment. There's no impediment at all. Okay, I see one question which asks how would an interlocutory injunction be granted in an arbitration setting? Thus, the same test in American Cyanamide applies. You would aware that in Malaysia, arbitration is governed by Arbitration Act. Arbitration Act itself has a specific section which allows the court to grant interlocutory injunction to preserve the subject matter of the arbitration. The overwhelming consideration of the court is to preserve the subject matter of the arbitration. And that's the consideration that applies in arbitration cases.
All right, I saw there's a question about, is it not ex parte against natural justice? All right, I would say that ex parte is not against natural justice, because ultimately, if the ex parte injunction order is wrongfully granted or it doesn't fulfill the requirement, it is subject to challenge. It can be set aside as usual, as always, under Order 32 Rule 6, if I'm not mistaken. Yeah, it's under rules of court. So, and parties have a chance to go for an inter partes hearing. So I don't think there's I don't think an ex parte order is against natural justice, because the time limit, the validity of it is short. It's just for 21 days, and you have to serve within 7 days after your ex-parte order to alert the other party.
If I may just add on to that, it is true that natural justice requires all parties to be heard, and ex-parte doesn't exactly do that. But it's good that we try to uphold the natural justice as much as we can. But reality is that sometimes the urgency is real. For example, you have someone who is very malicious, has been harassing you all the while. It has recently escalated to spraying of paintings in your house, and you would like an injunction urgently. If this is not pursued urgently, and you would give him notice and he will appear before the court, and you all will be asked to exchange document before the hearing, then it will take a very long time until an injunction is in place. And that is definitely not in the best interest of the victim. The ideal situation is to stop the act of harassment right away and allow party the time to lay out their arguments. In the event that the so-called victim is wrong, then the victim can, then the person to whom injunction is granted against can still be compensated by damages. So that is how the law tries to achieve a compromise in between natural justice and urgency of the matter. Should I pick the next one?
Yep. Hayden, just now you mentioned about Majlis Perbandaran, is it? I saw there's a question of asking about what is the rationale for excluding Majlis Perbandaran from being considered as a branch of government.
Majlis Perbandaran, Majlis Perbandaran, usually they are incorporated by reason of an act. For example, let's say it's Majlis Bandaraya Johor Bahru. It will be pursuant to a law to say that, oh, okay, to this day, on this date, Majlis Bandaraya Johor Bahru is incorporated as a body corporate. As a body corporate, it means that it can act as if it's a corporate. It can sue and be sued. In that sense, it's different from the government machinery, such as the police force, such as the Inland Revenue Board. They do not carry that kind of function, because Majlis carry more function than that, more private function than that. For example, Majlis enter into contract. Police don't enter into contract with private companies. That it's not a widespread thing to do. That is the reason why Majlis, that's probably the reason why Majlis is excluded. Legally speaking, the court relies on the act that created the Majlis. The act says that they are a body corporate. And that's why the court takes the view that they are not part of the department of the government. So that's the court's approach is a very simplistic interpretation of the word.
I think this question is to you.
Okay, go on.
To you as well, about fortuna injunction.
Mm-hmm.
May I know the difference between bona fide dispute and good arguable case for fortuna injunction?
Bona fide dispute. Okay, they are. Please don't confuse them. Okay, bona fide dispute is the person who received the statutory notice of demand will say that I have a bona fide dispute against the debt, against the demand. And if I manage to convince the judge that I do have a good dispute against the demand, then fortuna injunction will be granted. But good arguable case is an argument that will be raised by the other side. The other side may come and say, oh, this person truly owes me money. I have a very good and arguable case against him. But as we have shown in the SSOB case, the court says that a good arguable case is not sufficient. You have to be more certain than that. For example, you either get a judgment debt or you have a clear and unequivocal admission of the debt. So those are the difference between the bona fide dispute and the good and arguable case. It's a different context. Is there a relation? Yeah. Could you give examples of interlocutory injunction in construction industry? Construction industry, interlocutory injunction usually involves cases either the lawyer or main contractor tries to limit the access to the site, or the contractor not willing to leave the site when demanded. But I think this issue will be more well covered if we can have a chance to put a written reply. Clarence, do you want to do the honor of picking we have time for a last question? Do you want to pick the last question?
Yes. All right. Is preserving the status quo is the only reason to apply for injunction? How about to prevent imminent harm, and what is the scope of the harm mean? All right. This would be the last question. So to answer this, I would say that preserving the status quo is not the only reason to apply for an injunction. Normally, when we apply for an injunction, it is, for example, if I'm a contractor, or if I'm the owner of this land, and then someone just squatted on my land without permit. So then this is a case where I can apply for injunction to compel or to injunct this bunch of people from entering my land. So it is to preserve your rights, and there's a threshold for you to prove. So it's actually not easy to obtain an injunction. And how about prevent imminent harm, and what is the scope? This would be under quasi-timid injunction, where you have to prove that there's an imminent harm, perhaps to your land or to you as a person. Then you go to court and apply for that particular injunction. And it must be a real danger to your assets or properties. Yeah, so I guess time is up, right, Hayden? Yeah,
I think those are what we managed to answer today.
Yes.
Thank you everyone for joining us. We will be making the necessary application for the CPD points to be allocated. Thank you very much. I hope that you all will stay tuned to our coming up CLE series as well. We have a number of topics that will be covered in the next one. We have our next 5 series will have intellectual property, the protection for house buyer, tax appeals, and as well as will, probate, and administration. The details can be found in our website, rdslawpartners.com, and we hope to see you in the next session.
Yeah, thanks. I hope this session is insightful enough. Thank you for joining us today. Take care. See you.
Bye.
Bye.